Hi, everybody. It is Joy and Scott Anderson from our Ask Anderson series, where we go through the most frequently asked questions that people want to know when they reach out to a personal injury attorney. And today we're going to talk about, is there a time limit to file a claim? Which I'm sure a lot of people ask because you get an accident, you don't know what the process is or what the structure is. So, is there a time limit?
So the answer is yes. There are a number of different time limits, and it depends on what we're talking about, the specific facts of an accident, as to how those time limits affect things. Just to give an example, a standard motor vehicle accident, some private citizen rear ends another private citizen, is going, at least in Colorado, is going to be a 3-year time frame. Every state is different. So there are some states that are shorter. I was told, but I don't know, that Tennessee was a 1-year time frame, whereas Connecticut, I was told, is a 6-year time frame. So it changes state to state. So Colorado is where I practice law and where I'm licensed to practice law. And I can tell you in Colorado, it is a 3-year time frame for a typical motor vehicle accident. But the reason I say it depends on the facts of the case is, let's say it is a Colorado State trooper who does not have lights and sirens on, and he runs a red light and hits someone. Well, there's something called the Colorado Governmental Immunity Act that basically shortens the time frame, and it is not a statute of limitations, but it is a notice requirement that says you have 6 months to give the government notice of a claim. And if you miss that notice, there's no waiver of immunity. So the what happened greatly changes the time frame. Similar, there is a something called the Federal Tort Claims Recovery Act. So if it is a federal government entity that causes an injury, you have to meet the time frame of the Federal Tort Recovery Act, which is a 2-year time frame. Same thing with, if you have a drunk driver, there's something called dram shop. Dram shop is basically tavern liability. So if a bar overserves someone and then sends them out the door where they're now drunk and run a stop sign and hit someone, the bar can have potential liability for overserving the patron. Well, dram shop claims have a 1-year time frame to it. So the specific facts can definitely change the time frame and the notices that have to be given, but a typical answer, at least in Colorado, is 3 years. There are also, the way you phrase the question, there's notice requirements to insurance companies that are written into the contracts. So for a contract claim, there is a duty to timely notify the insurance company of an accident. Now, what that duty entails has a lot of different interpretations. So that, some people interpret that to say, as soon as the accident happens, you need to immediately call the insurance company. I can tell you, I don't think that is a correct interpretation, but there are certainly arguments over whether that is the meaning of the duty to timely notify. Typically, the duty to timely notify an insurance company is going to be looked at in terms of, did you give an insurance company enough notice of an accident for them to be able to reasonably and diligently investigate an accident? So if you wait 2 years and all of the evidence has now disappeared, there's an argument that you haven't timely notified the insurance company for them to be able to do what insurance companies do by investigating and evaluating claims. But if it's 30 days later where you're notifying the insurance company, all of the evidence should still be there to where, in my opinion, people will have satisfied their duty to timely notify an insurance company. So there's, like I said, a lot of fact-specific things in there, that it's not a quick and simple answer, but that is a general answer.
Never easy. All right. So if I hear you right, you or understand you correctly, you have to notify the insurance company in a timely fashion, and that can be defined later. but you have up to 3 years to file a claim. So an insurance company can know about it, but you don't have to file a claim right off the bat.
Yeah, and filing a claim has a little bit of a different meaning when you say to an attorney filing a claim versus what you're thinking of, hey, I'm notifying people that I have a claim. So filing a claim would be what we just talked about on a timely notice, where I call up my insurance company and say, hey, I was in an accident, just FYI, this happened. That would be filing a claim. You have and the time frame by which you have to do that, like I said, is not a bright line rule. It is did they have a reasonable opportunity to investigate the claim? The filing a claim on a hard and fast deadline is what I talked about originally is statute of limitations. Typically, statute of limitations is the time frame by which someone either has to have their case settled and resolved, or have a lawsuit filed. If they a lawsuit filed, you don't have to have the lawsuit complete, but you have to have at least filed the lawsuit. So what happens is if those two things have not occurred, one of those two things has not occurred, then the claim is forever barred if you missed that statute of limitations, and no attorney can help you after that point.
Interesting. Good info. All right. Thanks so much. That's good clarification because people don't know, the process, and they get stressed when they've already been in an accident about what to do next. So they do have some time. They don't have to rush into anything in terms of filing a lawsuit. And that's good information to know. I mean, 3 years, do you really have people wait 2 years, 10 months?
So yes, I have certainly had a number of people who wait until the last hour and say, "Hey, can you help me?" What people should know is that most attorneys won't take those cases, and the reason we won't take them is it usually takes us months just to get all of the information we need to be able to prepare a lawsuit and do it properly. And so if someone comes to us at the last moment and says, "Hey, can you help me now?" Most attorneys are going to say it's too late. Even though you haven't missed the statute, you're too close to it for me to be able to do anything for you. And so people who wait to the last second usually don't have good news coming their way. The other thing that you had mentioned is people are, "Hey, I'm in an accident. I'm panicked. I don't know what to do." There are a lot of people who will get pressure from insurance companies to act quickly. And it's important to know that is bad pressure that is not legally enforceable. They will tell you things. I've had people receive letters or get phone calls from insurance adjusters who say things like, "If you don't act within the next week, I'm going to close the claim and it'll be over." And all of that is just BS designed to put pressure on people to do things that are not in their own interest. So it's important to know that those timelines given to people by insurance companies are usually designed to put pressure on people, but have no legitimacy in the timelines.
Love it. Another good tip. All right. And that ties into the next video, because in the next video, we're going to talk about, like, what if you've already engaged with the insurance company and they are pressuring you and you don't want to take action? What is your next step? So that's the teaser for the next one, because my guess is that happens a lot.
It does.
So, all right. Thanks so much. We'll see you in the next one.
All right. Thank you.